Thanks so much for joining us here on Atlanta News First Plus. I'm Joy Lim Nackerin here with attorney Holly Waltman. Holly, thank you so much for being with us. It's always really a privilege to get you on here and have you share your legal analysis. So I invited Holly here today because we want to talk about a couple of top stories that have a really strong legal element to them. First of all, if you were watching on our secondary stream, our special events stream throughout the morning, what you saw was a hearing involving one of the defense attorneys for Mr. Trump's co-defendant. So essentially, this is testimony surrounding Fulton County DA Fani Willis. And remember, we've been covering the disqualification hearings and so forth. And so Ashley Merchant, who is the defense attorney that I mentioned, was subpoenaed to testify before the Georgia State Senate Committee hearing. I think both of us were kind of tuning in and out as we go about our day. Holly, what were your initial impressions?
I thought to myself, what a unique situation. Not only did Ms. Merchant file this motion solo on behalf of her client, Mr. Roman, but then later to have other co-defendants join in, and then now after the evidence of the hearing has been concluded and prior to getting the judge's decision in this case, she is the first person to be subpoenaed by the investigative body looking into this. And so in a way, what a unique and cool opportunity as a defense attorney. And of course, we all know, I know Ashley Merchant and we are colleagues and friends, but what a unique opportunity and position to be in as a defense attorney. She almost got to present the evidence that she was seeking to get as an attorney, as a witness to a different body, a legal body. So an unprecedented and probably never before seen situation, at least as far as I know, in the criminal realm of defense litigation.
Yeah, and I mean, of course, not all the questioning was friendly. And towards the end there, I listened to Senator Harold Jones ask a few questions that I think, we're sort of holding Ashley Merchant's feet to the fire. It sounded to me like there's going to be more questioning tomorrow, that it wasn't quite yet finished for today, just in today. But was there anything that you thought that could be harmful or helpful in particular to either side?
Yeah, so certainly, look, this was the first person to be subpoenaed. I think that you're correct, Joy. I think that we will potentially see additional testimony later on. This was more of I guess I'll call an informal setting, in the sense that it was more conversational. There were obviously way less objections. It is not adversarial in the sense that there was not anyone from the state there, in the sense that it's a hearing, right? She is a witness in this hearing. Additional subpoenas could be sent out on behalf of the investigation to hear from other people. I just thought it was profoundly unique. I do know that Ms. Merchant, along with most skilled defense attorneys, are not scared or shy away from harsh questioning or cross-examination, if you will, is what it kind of seemed like she was getting there at the end from one of those senators. But I thought she did an incredible job holding her ground, making her points, and not making this emotional or personal.
So Holly, I guess at the end of the day, really the question is Fani Willis going to be disqualified from prosecuting the case against the former President Donald Trump and his allies? Is Nathan Wade, the special prosecutor that she appointed, going to be disqualified? What do you think that today's hearing did to move the needle on that topic at all?
I'm not sure that moved the needle on that very topic. What I can say is this: Judge McAfee is going to be the person that decides whether or not the Fulton County District Attorney's Office remains on this case, and whether or not to dismiss the actual indictment that they brought through the grand jury and the special grand jury process. This, however, is what I'm going to describe as the next level or the next layer of interest that certain bodies are going to have in Fani Willis's upholding of her job as elected district attorney and her appointment of special prosecutors to take on special cases. So today's hearing that we saw with the Senate investigating this is not going to be the one. They're not going to be the body that determines it. And Judge McAfee, he heard every bit of evidence that he allowed in that hearing. He delicately asked questions during closing arguments of both the state and the defense. I do not believe that his opinion on whether or not to disqualify this office, and particularly Ms. Willis, is going to be influenced by what we saw today with the Senate.
Okay, well, I appreciate you sharing your thoughts on that. Anything else that we should be keeping an eye out for? I do want to just point out, and I think you started to mention this, that you and Ashley Merchant are colleagues, you're friendly, maybe you'd consider her a friend. It seemed at times, especially during the questioning by Harold Jones, that, maybe she was thrown off a little bit, that it could be uncomfortable. Do you think that it was surprising to her that she was subpoenaed?
So, of course, I don't think it was surprising that she was subpoenaed. I do think it's interesting and might show a little bit of where their head is that she was the first witness to be subpoenaed. I highly doubt that she will be the last. I think that they will afford the opportunity of other parties to come. And like you said, Joy, I do consider her a colleague, a friend. The legal community, both in prosecution and defense, even though Atlanta is a big city, is fairly small, especially the number of attorneys that do the type of niche type of practice or specialized type of practice that we do. We all run in the same circles. I think you asked a question of what could we expect or what do I think that might happen next. I think that we're going to hear from other attorneys. I think we're going to hear from maybe perhaps some of the witnesses that defense counsel and co-counsel of Ms. Merchant for Mr. Roman wanted to try and bring into the case in front of Judge McAfee in this hearing and in this setting. I think that we will, I think we're several weeks off from hearing the end of Ms. Willis's legal troubles. I think Judge McAfee has stated that he wants to get that done pretty quickly. But even if win, lose, or draw for the defense or for the state in the Judge McAfee hearing, I highly doubt that this is the end that Ms. Willis will have to answer, or Mr. Wade for that matter, will have to answer for what has happened thus far.
All right. Okay, so I want to ask you about another legal topic that's making headlines today, and something that we're following very closely. Apologize, I'm just changing the graphic here to go to go with our story. So I do want to let everyone know that the YSL trial is dark for today, and we are expecting testimony to resume later on this month. Right now, what's happening are some various motions that the judge is hearing, and you know all about that because it's what you do. You file these motions for a piece of evidence to be admitted. The other side files a motion for it to be excluded, that sort of thing, and the judge makes a decision. This is coming in. This is staying out. Right. So that's what's happening. But in the meantime, there's a really interesting case that many say could basically be legal precedent for YSL, and this is what I want to pick your brain about here. So just yesterday, the state Supreme Court overturned a murder conviction on the basis of essentially a rap music video that was shown to the jury. So this rap music video was shown to the jury during the course of the trial. The defendant here was found guilty of murder. The video was actually filmed several months prior to the incident, to the murder. And the higher court found that the lower court shouldn't have allowed that video to be shown to the jury because it was prejudicial. And in fact, it was so prejudicial that prejudice outweighed any probative value it may have offered, any value to, essentially prove anything in the case. And my understanding is that video was introduced just for the purposes of identifying the defendant, but apparently he was, waving a gun in it and so forth. But what are your thoughts on that ruling, first of all, and how it could impact YSL?
Yeah, Joy, this case couldn't have come at a better time to really intervene and kind of give us something to talk about, right? A debate to have about what is First Amendment speech. The idea that the state introduced a rap video of this defendant who is presumed innocent, waving a gun during some music video for the purpose of identifying him is kind of outlandish, right? There has to be, and certainly could have been, some other picture on social media or some other photograph that they could have had of him, a driver's license photograph perhaps, right? That's a state-issued, Georgia-issued license. That could have been something that they could have presented. But we all know the underlying reason why they backdoored or attempted to backdoor and successfully did so is to try and get the jury to feel some sort of emotion about it, right? And you hit the nail on the head. Did this unfairly prejudice the defendant from a trial that he is presumed innocent and is guaranteed under our Constitution to have a fair trial? And did that outweigh the probative value of identifying an individual? And certainly the trial court got it wrong. The Supreme Court of Georgia indicated that. And I do think it's important for our viewers, and maybe for some people that don't work in this area as often or aren't as familiar, this does not mean that this person's conviction is thrown out and he now is just free to go, right? This is now remanded back down to the trial level court and to the prosecution to decide, do we retry this case? Do we try and strike a deal with this individual so that we don't have to burden the taxpayers with a retrial? And from there forward, the best thing that he won would be potentially a new trial, in the hopes that he can get something fair, right? That isn't improperly prejudiced against him. Now, how this plays with YSL, I think is going to be very interesting because, of course, the defense position has been very clear. Brian Steele, along with all of the other co-defendants' counsel, have stated bringing in certain portions of Mr. Williams' art or his job or his career is going to infringe on the First Amendment right to express yourself, right? And just because you say that you did something horrible in a rap video or during art or during a performance doesn't necessarily make it the best evidence to present.
Yeah. So the thing is that Judge Earl Glanville, I'm just going to pop up some footage here of the YSL trial. Judge Glanville has allowed the use of rap lyrics and rap videos already to be introduced as evidence. The jury has already seen some of that stuff. So I guess you can't really undo what's already been done, but do you think that moving forward, that Judge Glanville is going to be a little more careful and more restrictive about what music videos and lyrics the jury can see and hear?
So jury trials are what we call the wild, wild west. And you know this, Joy, like the things that are allowed in the beginning may not be allowed halfway through. The things that were prohibited or excluded in the beginning on a pre-trial ruling from the judge, something might have happened during the trial to open that door of evidence and then now will later allow it. So I do think that Judge Glanville, he's a smart judge. He has tons of experience in his current position. He is going to review this new ruling and start to think about how he doesn't want this case to come back down if it were to come from a conviction on appeal back down for a retrial. Now, I do think that the defense counsel will renew all of their motions and probably add in the citation of this new case that is going to be published as persuasive or authoritative law on what is going to be allowed versus what isn't, and what is protected under First Amendment and what is not.
Yeah, so, essentially, one of the big concerns is that this could be a basis to appeal. So if they're successful, if the prosecution is successful, and there's a conviction here in this case, that would be one of the big concerns, right? Is then you've basically, by allowing this kind of evidence to go before the jury, you have given grounds to file an appeal to the defense. The defense could actually file an appeal, and the same thing could happen, that maybe a higher court could overturn the conviction and say, hey, look, the rap lyrics and music videos shouldn't have been shown to the jury, just like they did in this other case, right?
Yeah, that's certainly a possibility. I think that we have a chance here to see renewed motions from the defense to keep these things out. To the extent that this type of evidence has already been presented to this jury, we could see a motion for a mistrial from the defense. That's one option. Another option is a motion to instruct the jury from the judge to do a limiting instruction and have the judge say to the jury, hey, ladies and gentlemen of the jury, you previously have received evidence that was video oriented, and you need to give it this sort of limiting use, right? To use it only to, and again, I'm kind of ad-libbing here, only to identify the defendants in this case, or those sort of things. The challenge, and of course the danger in doing that, is what you said earlier. Once you've rang that bell, do you really want to bring the jury's attention back to it by having the judge re-instruct on how they should use that evidence?
Yeah, absolutely. Thank you so much for sharing your insights. Before I let you go, just want to ask you, to tell us a little bit about your practice, what kinds of cases you're interested in taking. Maybe one of our viewers is looking for an attorney. What cases do you take? How can people reach you?
So we represent individuals facing the wrath of the government all over the state of Georgia. We have offices on north of Atlanta, west of Atlanta. We go all over the state doing state, superior, and federal criminal defense for individuals. we're at thewaltmanfirm.com, and we're on most social media platforms at the Waltman Firm. And we are currently looking for summer interns. So please reach out to us and contact us if you are interested or you know someone who might be a good fit.
Definitely. And just want to point our viewers to our website, atlantanewsfirst.com. And you can actually you see right here, you can click on that story and you can read all about what we were discussing. This testimony by a Trump co-defendant's attorney regarding Fani Willis and Nathan Wade, and all of your other top stories, of course. Also encourage you to download our free Atlanta News First mobile news app, and that way you can get updates sent right to your phone. Thanks for being with us. Have a great day.